I am Hend Marwan. So me and my partners are going to explain about the difference of a duress under both the English and the Malaysian positions as a vitiating factor. Under English position, a duress is when a person enters into an agreement without his own consent, but under a threat, force or pressure by the other party to have a contract done. Although, if a contract is made under duress, then it will be considered as a voidable contract, whereas duress under Malaysian position can be known as coercion. Furthermore, under English law, there are three types of duress: duress of the person, duress of the goods, and economic duress. First of all, duress of the person is a situation where the claimant has been forced or physically threatened by the defendant to accept to enter the contract. As duress to person can be manifest in the situations of physical violence, unlawful concern, and threatened. As it was shown in the case of Barton and Armstrong, where both of the defendant and the claimants were shareholders in the company. Armstrong, the defendant, who had loaned the company some money and didn't get a rebate, had threatened his partner, Barton, that he will kill him and his wife if he didn't sign a debt and made all the arrangements needed to repay the loan and buy Armstrong's shares. The trial stated that the claimant didn't just sign the agreement because of the threat, but it was also for some commercial reasons. In the case, it was held that a person who agreed to a contract under physical duress may avoid the contract, even if the duress was not the main reason of agreeing. According to the previous case, a contract under duress can be avoided if the defendant showed a causal link between the alleged duress and the entry into a contract to be set aside, as the duress has to be a cause and not but for cause.
Next, another form of duress is known as the duress of goods. Duress to goods occurs when one of the parties holds the other party's goods until they enter into an illegal contract. In traditional English law, there are two general rules in which duress of goods occurs. In the first scenario, it involves where threats in relation to goods are insufficient to render an agreement voidable for duress. This rule came to be in the case of Skiat v. Beale in 1841, where the plaintiff in the case is strained onto the defendant's goods on the grounds that he still had rent that was owed to the defendant. In this case, the defendant decided to pay the arrears in the form of installments, which the plaintiff released the goods. However, the defendant stopped making payments, and thus the plaintiff sued the defendant. A refuting argument which the defendant used was that the agreement in which he was to pay the arrears was a voidable agreement due to it being made under duress. For the second rule, it pertains to the money that was paid under agreement reached due to duress of another party can be recovered. This decision was reached in the case of Astley v. Reynolds, in which case the plaintiff pawned goods which the defendant, and as a result, the defendant refused to take in the goods unless the plaintiff paid excess interest that was beyond the legal limit. After paying the excess sum of money, the plaintiff sought to recover the excess money paid on the basis that the contract was formed under duress and was, as such, voidable. However, as time moved on, this traditional viewpoint was soon garnered to be seen as a bad rule to stand by. This was first shown in the obiter by Kerr J. in the case of the Sibuan and the Sipoter, 1976, in which he mentioned, "If I should be compelled to sign a contract under an imminent threat of having my house burned down, or a valuable picture slashed, true without any threat of physical violence to anyone, I do not think that the law should uphold the argument." After this obiter dictum was made in the High Court in the 1970s, it wasn't until Lord Gough in the case of the Evia Luck 1992, which was a House of Lords case, ruled that the Skiat v. Beale was no longer a good law, and thus agreeing with Kerr J's obiter, which allows the duress of goods to be able to make a contract voidable.
Economic duress, on the other hand, refers to the situation in which a party of a contract has a power and threatens to cancel the contract unless the other party agrees to their terms. The first instant in which economic duress as a concept was first recognized in the case of the civil and the suitor. In this case, the plaintiff, which was a ship owner, was under pressure to sink into the demands of the defendant, which threatened to terminate said charters if the ship owners in question did not lower the hiring rates, in which the defendant were unable to fork up regardless, in knowledge that he would be suffering a huge loss if the ship owner did not gain the charters. He lowered the rates, in which he subsequently sought the recovery of the money that was lost due him lowering the rates. The courts, however, ruled that this was just a case under commercial pressure, as there was no moment in the case which could be regarded as coercion of the ship owners, which would cause his consent to be different. In the essence, the plaintiff must have entered the contract involuntarily for it to fall under duress. It was in the case of the envelope, in which was under the House of Lords decision that economic pressure should fall under duress if it was met under two requirements. The first requirement was that the economic pressure that was exerted has to be characterized as illegitimate, and secondly, must be a significant reason for the plaintiff to enter into a said contract.
Next, I'm going to introduce you the Malaysian position. So in Malaysia, contract law is basically governed and enforced by Contract Act 1950. The forms of duress are subsequently covered under several sections of the CA 1950. Generally, a contract is not enforceable if its object is considered to be illegal or against public policy. According to Section 15 of CA 1950, the coercion has been defined as follows. It is a committing or threatening to commit any act forbidden by the Penal Code or unlawful detaining, threatening to detain any properly to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. When entering into an agreement, the parties must have free consent to contract, which is provided in Section 10, subsection 1. All agreements are contract if they are made by the free consent of parties competent to contract. Under Section 14, consent must be free and not caused by coercion as defined in Section 15. Section 13 also tells us that the party must agree upon the same thing in the same sense. Since the consent is not free consent in the cases of coercion, the agreement that comes into existence is voidable as the opinion of the party whose consent was not free. There are several main elements of coercion under Malaysian law as follows. 1. Commitment of an act. When any one of the contracting party himself or any third party on his behalf commits any act which is forbidden by Penal Code, it's treated as coercion. 2. Threatening to commit an act. When the act which is forbidden by the Penal Code has not been actually committed, but one of the contracting party himself or any third party on his behalf threatens to commit such an act, it is said that coercion has been applied. 3. Unlawful detaining of property. When any of the contracting party detain unlawfully the property of any other party with the intention of bringing him into contractual position, it is said that coercion has been applied. 4. Threatening to detain the property. When the party has not actually detained the property of another, but threatens to detain, if the other party does not enter into agreement at his desire, it is said coercion has been applied. 5. Prejudice of any person. The word prejudice suggests that there must be some detriment to the innocent party, implying that there must also be some substantive unfairness, and the prejudice might be to anyone. 6. Intention of causing any party to enter into an agreement. 7. As with common law, the coercion must cause the innocent party to enter into the agreement.
It was proven that the result of the allegations of duress was to render a contract voidable. Therefore, this would allow a party to request the contract to be rescinded and seek for restitution of any money paid under the contract. However, there are three choices which are available to the innocent party to choose, which is to affirm the contract, rescind the contract, or when sued on the contract, could raise duress as a defense. When a contract is held to be voidable, it indicates that the contract would still be legally binding until it gets rescinded by the party, regardless of the issue where the contract has actually been affirmed. If the party affirms the contract either expressly or by their actions, any rights to cancel the contract will be lost. Other than that, if the party failed to set the contract aside within a reasonable time after ceases to take effect, may lead to the following conclusion, which is the agreement has been affirmed and cannot be set aside. Since the contract remains valid until it is rescinded by the innocent party, the bona fide purchaser for value without notice of the rotating factor may obtain good ownership of the contract subject matter through the party guilty of duress. However, if the innocent party makes the choice to not affirm the contract, the party who is guilty will not be able to execute the contract if the victim raises duress as a defense against any claims in the contract. Once it is affirmed, the right to rescission will not be available, or if the other bars to rescission apply. The question at hand now is, why are contracts induced by duress voidable? This is due to two reasons. First is that the victim does not agree to coerce because the will of the victim is overwhelmed. This is known as the Overborn will theory. In this theory, the court looks into the will of the victim, where it focuses on the validity of victim's consent. The contract is considered voidable because the victim who refused the validity of the contract did not freely agree to it when signing the contract due to duress. Secondly, although the victim did express genuine consent, he did so due to undue pressure by the other party, known as the illegitimate pressure theory. The focus here is on the actions or the behavior of the guilty party, i.e., the person instigating and the person trying to enforce the party. It is alleged that the party has committed legal misconduct, so the victim can choose to set aside the contract.
The effect of coercion under Malaysian law is similar to the English law, but it has to be referred to the Contract Act 1950. Under Section 2, Subsection 1 stated that if an innocent party can prove coercion, and a contract will become a voidable contract, which means the innocent party has the option to either affirm the contract or rescind the contract. Next, under Section 19, Subsection 1 of the Contract Act 1950, if a party was consent to enter into an agreement by coercion, then the agreement can become a voidable contract at the option of the party. An example case that the contract has been entered under coercion in Malaysia is the case of Uterian Sebastian Pillai and Stevenson Urinaton Law 2019, where the relationship of both parties have been deteriorated and the negotiation were going through several months to resolve the disputes with regards to the ownership of the land, shop lot, and shares in the company. During the negotiation, the defendant lawyer threatened the plaintiff that the plaintiff had committed financial wrongdoings and threatened to report him to the police and have him arrested for the alleged wrongdoings. There's a kind of pressure when a plaintiff signed both agreements where there were two policemen waiting outside and were negotiating ostensibly to arrest the plaintiff. Also, both agreements were grossly disadvantageous and blatantly unfair to the plaintiff. Therefore, the plaintiff wants to rescind the contract as he was entered into the contract under coercion, and the lawyer advised the plaintiff to complete an audit of the account of the company to make sure he was not guilty, and this took some time. Subsequently, the plaintiff took action against the defendant to rescind both agreements. Therefore, the court held that the defendant here has fulfilled the four requirements under coercion, but the defendant tried to bring a defense stated that the plaintiff has delayed while rescinding the contract. The court stated that the delay is reasonable as the plaintiff is finding an auditor to check and prove that the plaintiff did not commit any financial wrongdoing, and the plaintiff took that to eliminate the traits and send a letter of demands. Furthermore, the effect of rescissions under English and Malaysian position are quite similar. Under English position, when a contract is rescinded, the court will strive to restore the parties to their original state as much as possible. Even if the contract is not rescinded, damage will not be allowed. However, in such cases, innocent party may raise Duress as a defense. Whereas under Malaysian position, the effect of rescission will be covered under Section 65 and 66 of the Contract Act 1950. Under Section 65, the innocent party has the option to rescind the contract if the innocent party has given some amount of money as change because of the agreement of the wrongdoer. The innocent party has to return back any benefits that he or she have received under voidable contract. Moreover, under Section 66 of the Contract Act 1950, if an agreement is discovered to be void or become void, then any party who had received any advantages under the contract must restore and return back any advantages received or make compensation. Even if Section 66 did not mention the voidable contract, but there is an obiter made by a judge in the case of Yong Mok Hin against United Malay States Sugar Industry, mentions that the voidable contract will become void contract by rescissions. Hence, the effect of Section 66 is to provide that both parties of the contract must restore back any advantages received or make compensation for it under the contract. And Section 66 is a provision that seeks to achieve restitution in integrum. Another case that can be referred to is the case of Sagru Prasad against Harnarin Das. In this case mentions that the words "when a contract becomes void" are sufficient to cover the case of voidable contract which has been avoided.
Additionally, the remedies for a voidable contract under English and Malaysian position are the same. Hence, the only remedy that is available for the victim is that he has the right to rescind the contract, but with the requirement that there are no equitable bars to rescission, which are the affirmation of the contract, time lapse in rescinding the contract, both parties cannot restore to their original position before the contract is rescinded, and also the interest of the bona fide purchaser would be affected once contract is rescinded.
The difference between duress and coercion is that Malaysian law has a wider scope than English law. The penal codes cover a wider range of criminal offenses. To start with, the position of duress to goods under the English common law is slightly narrower compared to the definition of coercion provided under Section 15 of the Contract Act 1950. Section 15 is bordered in the sense that it covers unlawful detention of property. It expressly recognizes the rights of goods. What's more, the prejudice of any person is not mandatory in common law. The focus is rather on procedural unfairness, not substantive unfairness. Not only that, there is a distinction in terms of involving parties to the contract, which is that third-party involvement is not covered under the common law. Thirdly, economic duress is not expressly stated in Section 15, as the definition of coercion is very limited. High Court held that Contract Act 1950 does not provide any forms of coercion other than as defined by Section 15. Last but not least, intention is not a part of duress under common law.
Also, there's some criticism for coercion under Malaysian position which is not similar to the English position. Under Section 73 of the Contract Act 1950 can be considered as an independent act. Under this section, the purpose is not rescind the contract, but only to take back whatever money that has been paid or anything delivered. This section basically stated that a person must repay and return whatever money that has been paid or anything delivered. Hence, there's a question that needs to be questioned in court is whether the coercion under Section 73 has a wider meaning than the coercion on Section 15. Hence, this question was clarified in the case of Chin Nam B Development SB against Tai Kim Cho 1988, where the developer threatened the defendant that he would cancel the booking if the defendant did not pay the developer the extra 4,000 ringgit. The buyer paid the 4,000 ringgit and subsequently brought a claim against the developer for the extra money paid under the grounds of coercion by relying on Section 73 instead of Section 15, since the claimant's action would not amount to coercion under Section 15. Therefore, the court held that the claimants entitled the refund under Section 73. Also, coercion in the contract of Section 73 of the Contract Act 1950 should be given its ordinary and general meaning, since there is nothing under the Section 15 stated that the word coercion should be given the same meaning throughout the Act. Therefore, Section 73 can be considered as an independent act, which means it stands on its own and is not related to Section 15.
Another differences and criticism is that the economic duress is not satisfied under Malaysian position, because it is not very clear as stated in the case of Perlis Plantation Berhad against Muhammad Abdullah. In this case, Justice V.C. George mentions that the Contract Act 1950 does not provide for any form of coercion other than as defined in the Section 15, which means Section 73 cannot be used and will be referred to Section 15. Next, there are two cases with regards to the claims under economic duress which were not succeeded. For example, the case of Tet Guan Trading against Hydrotic Engineering, the court held that there is no coercion under Section 15 and economic duress, as the transaction was in the ordinary course of business between parties dealing at arm's length, but the judge have referred to the guidelines in the case of Pao On against Lau Liu Yong in reaching his decision. Another case which can be referred is the case of Muhammad Farid Subramaniam against Naza Motor, where the judges James Fong also applied the principle in the case of Pao On to determine whether there is an economic duress or not. Hence, it can be seen that the court did not expressly say that Contract Act 1950 allows for economic duress, but impliedly for the plaintiff to claims under economic duress as referred to the guidelines in the common law case. In the case of OCBC Securities Sendirian Berhad against Ko Kee Huat, Justice Law Hok Beng also mentions that the court are slow in invoking the concept of duress as defined under Section 15 of the Contract Act 1950, or to import the concept of economic duress unless there is a positive evidence to that effect, which must satisfy the guidelines in the case of Pao On. Last but not least, if Contract Act 1950 does not have any provision with regards to the economic duress, the court can refer to the common law, as Section 3 and Section 5 of the Civil Law Act mentions that if there is a lacuna in the Contract Act 1950, the court can refer to the common law and follow the case with regards to the economic duress.
At the end of the day, in the realm of law, there are major similarities between the laws that govern duress in UK and Malaysia's legal system, in which parts have distinct areas in which separates both of them and make them unique in their own right. A stark difference is in the scope of its jurisdiction. Malaysia, as compared to the UK, has a much broader scope for duress or coercion due to its penal code that covers a wide area of criminal offences. But, as a consequence to this, illegal acts that do not fall under the penal code hold no ground and can be brought to court via the pathway of coercion. In pertaining to duress of persons, Malaysia and UK are under the same lid in recognising and utilising the general rules that come out from the case of Barton v. Armstrong. Economic duress, on the other hand, falls under a limbo in Malaysian law as compared to UK law. An explanation of this is that economic duress's concept as a whole was recognised, even though not accepted, in the case of the Sibuan and the Sibotar, as compared to Malaysian law, in which this haziness continues due to the fact that economic duress is not expressly stated in Section 50 of the Contracts Act 1950 due to an extremely limited definition for coercion. Through further cases and development in Malaysian law, the principle of economic duress was recognised. However, it is yet to be established in cases. A potential suggestion to improve the law of coercion in Malaysia would be allowed to broaden the penal code to allow more exceptional circumstances to a certain extent that would not cause a floodgate problem. Besides that, certain amendments could be made to allow economic duress to be more explicitly stated and recognised, giving more legal pathways for people to bring a claim under coercion.